Hi, Christian. Can you hear me? Hi, hello.
Yeah, I can hear you. Can you hear me?
Yeah, perfect, perfect. Nice to see
Excellent.
you again.
Yeah, likewise. I'm back in Copenhagen and I'm already got a cold.
I'm pretty sure. I mean, just to be very clear, the conversation we are having is live streamed on YouTube. So yeah.
Ah, oh, I've never tried that. As you know, I'm experimenting a bit with YouTube, but I'm not very good at it. But I managed to, I've managed to upload a couple of videos, and I also made one of them into a premiere. I have no idea what I did, but then it was counting down.
Yeah,
So
yeah, yeah, 100%.
I see a lot of potential in this, but to be honest, I'm I'm not really an expert on it. Anyway, you got my
Yeah,
presentation.
yeah, yeah. We have got your presentation.
Okay,
So Nikita has already joined. Weber and Spurti are gonna join in some time. We anyway are 5 minutes early, so that should not be an issue. And the
okay,
participants would join in on Zoom, and the participants might also watch it on YouTube because we are live streaming there. So yeah, that would not
okay.
be an issue.
Yeah, but my student love Zoom lectures because then they could just lie on their couch and eat chocolate or whatever they want to do. But personally, I hate it because I cannot see if they're actually participating or they're just checking out Facebook. So.
Well, most certainly.
But there's a huge potential in it. But of course, there are downsides to everything.
True, 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 true. That's that.
Now, would I be able to manage my PowerPoint presentation myself?
So that is possible. What I'll do is I'll just make you the co-host. If that's the, I'll just make you the
Okay.
co-host. Just give me a second.
Yeah, but yeah, okay,
I
that
have
would.
just
But I don't know what is most efficient because I can also tell you when to move between the slides if that's something you prefer.
exactly. Exactly. So, I mean, we are fine with both. Vikrant, if you can just help me making Christian the co-host, so we can do both. If you all want to manage your slides yourself, that's also fine. Otherwise,
Yeah.
we'll be able to slide
Hi,
it off.
Christian.
Hi.
I I am making you the co-host.
Excellent.
Yeah. I
So,
guess.
Christian, actually, Nikita, we could not get you meet with Christian when he was at the BRICS conference. Christian, Nikita is one of the advisors to the center. We really wanted you to meet Nikita, but I think due to schedule issues, we could not.
Hi,
Yeah,
So,
but
yeah, I mean,
I will just have to come back then.
yeah, most certainly. Most welcome.
Speaking of, I got an email from Morten,
Yeah.
and he's still working on a way to get you. The way I understood it is that you have applied for some kind of scholarship, and he says it's out of his
Yeah.
hand, but he hoped that it pans out fine.
Most certainly. So Spurti has also just joined in. Yeah. Hi, Spurti.
Hi, Sumit.
Christian and Nikita are already here. We are waiting for Vaibhav to join us. Some of the participants are already in the waiting room. They would be joining us on Zoom, and some of them would be joining us on YouTube. So we really need not have to wait for them. We can start at 6 or 6 at maximum.
Okay, sure.
But can I test if I can actually use my PowerPoint presentation? Oh, I can.
Yeah,
Can
yeah,
you see
please,
them?
please do. Yeah, yeah, we can see. We
And you
can
can
we
also
can very
see.
well see.
Okay, excellent.
Yeah. So what I propose, Christian, Nikita, and Spurti, is that we can have 2 rounds of sort of comments, and then every speaker can sort of give concluding remarks if that works for everyone.
Yeah.
Nikita and Spurti, is that fine?
Yeah, that sounds fine. That's okay.
Yeah, that works for me too as well.
Perfect.
Am I visible? Is this
Just give me a second. Yes, Nikita, you're visible.
all right? Great. Thank you. Just wanted to check that once and get it out of the way.
Vaibhav has also joined us in. He is named by A Block.
Sorry, I'm just changing.
Hopefully, yeah. Hi, Vaibhav.
Hi, how are you?
I'm good, Vaibhav. So, Vaibhav, Christian, Nikita, Spurti all have joined. Deeksha won't be able to join. There was some last minute engagement for her. She messaged me today morning itself.
Sure.
So, it's already 6 o'clock. We can wait for 2 minutes. So, some of the participants are on Zoom and some of the participants are on YouTube. So, we can start off whenever you say me.
Sure.
The line we can possibly have 2 rounds of comments and then each speaker can give concluding remarks if that works well.
Certainly.
Perfect. So we'll just wait for 2 minutes or whenever you are ready, I'll start off.
So whenever. Hi, good evening, Christian. Good evening, Nikita.
Good evening, Weber. Good evening, Christian. And hi, Spurti ma'am.
Hi, Spurti.
I cannot possibly.
Hi, Nikita. Hi, Vaibhav.
So I think we can possibly start. Good evening, everyone.
I'm so sorry.
Yeah, yes.
I'm sorry. I'll just quickly intervene. So how do we go about it? You're going to be, how are we going to conduct the moderation?
So for every question, possibly Christian can start off, Weber then follows, then you can follow Weber and then Spurti. 2 rounds each and then concluding remarks.
All right. Sounds good.
Okay, thanks so much. Good evening, everyone. I welcome all to a virtual conference we are hosting on the recently published draft lesser penalty regulations by the Competition Commission of India. As some of you might already be aware, the Competition Act was recently amended by the Parliament. We are now governed by provisions of Competition Amendment Act 2023. Some of the provisions, substantial changes which have been brought by the legislature into the amendment is introduction of commitment and settlement scheme, a time cap on the receipt of the framing of information, strengthening of the leniency regime, change in the definition of relevant product market, and so on and so forth. We have been able to gather a line of quite expert speakers in the field, and I'm honored to introduce them to the panel. So we have Professor Christian Bergquist from University of Copenhagen joining from us. A brief introduction about Christian. Christian is an associate professor at the University of Copenhagen. He specializes in competition law in general, with particular interest to its application to deregulated and network-tied sector, which is telecom, energy, and transport. He completed a PhD thesis on the regulation of network-tied sectors, which is telecommunications and energy, and the application of competition law to these. Prior to this academic position, he served as a lawyer for 5 years representing clients before the judicial administrative bodies. He still functions as off counsel to selected cases, and he is also an advisor to the International Competition Network. I welcome you, Christian, to the panel. Then we have Mr. Vaibhav Gaggar. Mr. Vaibhav is an arguing counsel before the Supreme Court of India. With over 2 decades of experience, Vaibhav has a number of watershed judgments to his credit, especially in the commercial litigation, white-collar crime, and competition verticals. Vaibhav has been acknowledged as the conceptualizer, architect, and author of the Nagaland Prohibition and Gaming and Promotion and Regulation of Online Games of Skill Act 2016. He is the chairperson of the disciplinary committee of the All India Football Federation and was recently appointed as a member of the AFC Appeal Committee. He is also the former co-chair of the PhD CCI Law and Policy Wing. Prior to being a counsel, Weber was the founder partner of Gaggar & Partners. Welcome, Weber. Thank you for accepting our invitation and being a part of the panel. Then we have Ms. Nikita Kuradia. Ms. Kuradia is an assistant professor of law at Institute of Law, Nirma University. She specializes in the subject of competition law and has vast experience in teaching. She has pursued her double masters from Penn State Law State College, US, in the field of antitrust as a Penn State scholar, and from University of Warwick, United Kingdom, in the field of international corporate governance. She has completed a PhD from Gujarat National Law University. Nikita has also been awarded the Legal Excellence Award by ASSOCHAM. She regularly publishes in peer-reviewed journals and recently contributed a chapter on leniency regulations under Indian competition law. She is also an advisor to the center. Lastly, we have Nikita. I would like to thank you for accepting our invitation and being a part of the panel. Then we have Mrs. Spurti Krishna. Spurti Krishna is an assistant professor at Vinayak Mission Law School, Chennai. She teaches competition law, contracts, and family law at the university. Spurti regularly publishes in peer-reviewed journals and recently contributed an article in Humanities and Social Sciences Studies Journal. Before her academic position, she has worked at the law offices of Shriram and Tatva in Hyderabad. She is a graduate of Karnataka State Law University and a master's degree from Amity University. Spurti, thank you again for agreeing to be a part of the panel and adding a unique perspective to the same. I'll start off with possibly a very broad question, and I think Christian has sort of also made some slides to delve on the question. And my question to all the panelists is that, for the benefit of participants, what is the whole concept of leniency regime under competition law? If they can dwell into the larger legal and economic jurisprudence under why leniency is required in the first place. If Christian, you can start off and you can give us an European perspective, followed by Weber giving his unique litigation experience, and then followed by Nikita and Spurti, who are given an academic perspective on the same.
Yes, and I will use my slides to explain it, if that's okay with you.
Absolutely, Christian. Please go.
Okay. I have to make an important disclosure is that, I just came back from India and, I really loved it, but I have a limited understanding of the enforcement system in India. So I will, sort of limit myself to speak about the European experience. But I understand that you are contemplating to introduce a leniency system, and that's actually a very good idea. And there are many reasons for that, because, leniency and the risk that you are in the cahoot with some co-conspirator who actually are leaking information to the authority, that's destabilize cartels. So it is actually a way of making cartels collapse, but it's also a way to allow companies to get out of a cartel that they accidentally ended up in without have any true appetite for being part of infringement. So, having a leniency system is actually a very good idea. But you need to understand that when we talk about leniency, we can actually talk about different kind of instruments. Just to give you some backgrounds, traditionally you would have a case that moved forward, and then a decision would be rendered, a fine would be imposed, and remedies. Then the party might go to court. However, across the year in Europe, we have sort of introduced a couple of alternatives. You can get leniency, and that is either you get complete immunity, there's no fine whatsoever, or you get a reduction. The difference between about immunity and reduction is, of course, you don't get any immunity if you only get a reduction. But leniency in terms of immunity are only available for the first one who come forward. Subsequently, also give discounts, but it has to be the first one who gets immunity. However, as of 2008, the European Commission introduced a sort of a settlement, which in some aspect is an alternative to leniency, but it's also complementary. And then we have a third way of closing a case, that is commitment. Now, it is important to understand that these are in principle not alternatives, because the idea is that leniency are only available in the initial time frame. that is when the commission is not really aware of an infringement, or they might have a suspicion, but they don't really have evidence. If you come forward and approach the commission, then you can get immunity. And that is, of course, easy to understand because you essentially help the commission to identify or prove an infringement that they did not have any knowledge or they did not really have the full picture. There is a window that closes. I'm not entirely certain when the window closes in practice, but in principle, it closes when the commission has sufficient evidence to actually make a decision. Then you can no longer get leniency, but you can do a settlement instead. And a settlement is essentially that says, yes, we did it. We're not going to challenge it. We're not going to ask for access to the file, and we accept a reduced statement objection, which makes the commission's life so much more easy. Because in many situations, it's pretty obvious that you have infringed competition law, but there are not really any mitigating circumstances, but you are willing to admit it, and you just simply want to move forward and forget the entire case, pay the fine, and focus on something else. And this is really helpful. These are in principle alternative. I mean, there is a window that closes, but in practice, they can actually be combined, which means that if you cannot get immunity because you're not the first one who come forward, you are only able to get 50% discount, but you can get an additional 10% by acknowledging everything and essentially assent not to challenge the case. Now, a completely different animal is commitment. Commitment is when there is no case, but there is a feeling, there might be some complaints or some other stuff that looks suspicious, but it is not really something that looks hardcore and there are mitigating circumstances. Typically, it could be something vertical, or it could be abuse, a refusal to supply, but you didn't really know that you were dominant. In such a situation, you can simply avoid a complete case by offering commitment. So leniency, settlement, and commitments are three different things, and you should never really blend commitment with a leniency settlement situation, because commitment is not warranted in a situation where the circumstances of the fact actually dictate a case. Now, there are essentially leniency is essential for the commission's ability to make decision. I have not been able to find any updated statistic, but I think a couple of days ago I saw a press release from the French Competition Authority saying that approximately half of all the decision they made was actually based on leniency. I would imagine it to be even higher at European level. So it is essential for the Commission's ability to identify and pursue hardcore infringement that company comes forward. And so they are massively beneficial for the Commission. Now, the problem from a company perspective is that if you ask for leniency, or you essentially acknowledge that you have infringed the law, so you open yourself for follow-on litigation. It is so much more easy to sue a company and ask for damages if they have acknowledged every single element of the infringement. It's difficult for them to deny having done anything wrong. So the situation right now is that the leniency system has been very helpful, but it is currently being undermined by private enforcement, and companies say that they are unwilling to really go for leniency because they expose themselves for follow-on litigation. Moreover, you only get leniency at the European level, but you can still be sued in America and in many European jurisdictions. That means that commitments are very attractive from a company perspective because you do not acknowledge any kind of infringement. The problem is, of course, that means that case law are not really developed. And it might also, but now I'm speaking, personally capacity, it might make it very easy for the Commission to open a bad case because they know they not actually have to develop it, so they can close it against commitment. Now, the problem is actually that the leniency system, at least that is the way the Commission presented, is the leniency is actually being undermined by national enforcement and the fact that, companies or their lawyers who feel that they have suffered a loss, they ask access to the file. And that means that they can actually get the confession. So companies say that they are unwilling to go for leniency because they inflate the risk of follow-on litigation. And of course, what everybody is mostly afraid of traditionally has been being sued in America. So the commission has actually accepted you don't even have to submit written evidence. You could even do an oral explanation, because the idea is that you do not have to present that during a discovery process. But in order to make the leniency system more efficient and protected, the Commission has taken a couple of steps, like, for instance, adopting directive, essentially harmonizing the leniency system across the European Union. And they are also contemplating, but do not think that will happen, to extend leniency also to cover follow-on litigation. So the main point is the leniency is really, really good. It is actually a cornerstone of the system, but the system in Europe is, I wouldn't say being undermined, but there is a threat from follow-on litigation. So you should also consider to which extent this is a problem in India. Now, what I have done here is that I have listed a couple of notices from the European Commission where they explain some element of the leniency system. And as always, I'm available for discussion subsequently.
So yeah, thank you so much, Christian. Whenever I come to you, and I mean, since you have basically were running a law firm for a decades, and now you are a full counsel. My question is, what I find really interesting is that when it comes to a jurisdiction like Denmark or say European Union, Christian is saying that there is lack of case laws, right? So I mean, and he has very clearly sort of clubbed this commitment, settlement, and leniency, which is known as larger amnesty program. So what has been the Indian experience more from an practitioner's viewpoint, I think, so that would be very helpful. Weber, you're on mute.
Sorry, can you hear me now?
Yeah.
Sumit, we've had leniency ever since the beginning, right? Since 2009 onwards in India. Commitments and settlements are new, so there's absolutely no jurisprudence around that as of now in the country. Even though, as Christian pointed out, that's being treated, I mean, as far as the companies are concerned, they don't know which way to swing on it because they don't know what the attitude of the regulator is going to be, right? The biggest fear for them is, they end up going and making a commitment or a settlement where there may not have been sufficient evidence as well. And it does kind of open up avenues for future as well. You've kind of come in the radar, so as to say. But as far as leniency is concerned, we do have, a bit of jurisprudence over the last 1 decade, right? And what we have now in the draft proposal is a leniency plus provision. So let me just, kind of break this down for the ease of convenience for everyone here. Leniency effectively means whistleblower, right? So if you're part of a cartel, you go and say, listen, I was a part of this cartel. This is the evidence that is there. These are vital disclosures. And, that empowers or, gives the necessary material to the CCI then to go and investigate into the offense, bring on board other cartel members, prosecute them, etc. And the reason for that is, the first principle of cartels is that, they're hatched in secrecy, right? So globally, and, in the EU or the US is more than 100 years old as well, cartels are the most difficult form of cases to kind of crack open from a prosecution perspective, because a wink is often enough to signal an acceptance, right? You will hardly ever have emails being written between members or conversations which are totally in front of other witnesses, etc. Right? So the problem that was being faced by the regulators globally was, how do you crack into it? You may smell it, but you don't know, you don't have enough access to it. And that's how the leniency regime was brought about. And what does it do effectively? So from the regulator's perspective, it provides, even in cases where they weren't necessarily looking, they've got now a starting point. B, in cases which have already been initiated, perhaps they've got evidence coming their way. C, not just evidence, but a lot of things which should have never gotten disclosed would come to the surface. D, a lot of evidence, in terms of, say, a WhatsApp conversation between two people, right? Very difficult to get hold of that. But if I'm a leniency petitioner, I would be disclosing all of that as well. So a lot of other conversations come into play. You will have footages which may be available, again, something which is very difficult for people to crack. So it kind of becomes a lot stronger for the CCI to prosecute. Plus, what it does is that, at least in India, it's called a suo motu case, right? Now, the moment it's a suo motu case, the other people who are being prosecuted or are being investigated know that this is a leniency matter. Now, imagine there is, the four of us on the panel, one of us is the whistleblower, the other three are saying, oh my God, right? This guy is gone and blurted it all out. Do we even put up a defense anymore, right? Because if you do put up a defense in a cartel matter where there is a whistleblower, then rest assured the commission is going to come after you very hard if it finds you guilty eventually, right? Because they're saying you had an opportunity, whether it's by way of a commitment or a settlement, or by way of being a second whistleblower, because we've had in India cases where every party became a leniency petitioner. And it became a mad race to say who gets that application in first, right? Because the first one, and this is really more for the students, I'm sure the panelists already know, but the first one gets 100% potential waiver, right? And these penalties could run into hundreds of millions, if not $billions as well, billions of dollars as well, right? So it's a very big deal who gets the application in first. And it's a litigator's delight, right? Because if it's a global cartel, and I was part of one where this was an alleged global cartel in the auto segment, right? And you had leniency petitions being filed in Japan, Korea, India, EU, Brazil, Argentina, not Argentina, and one more country, I'm forgetting, all the same day. And within 6 hours, you had a second application coming. So there was, Chinese whispers going on even between the competitors at that point of time to tell you how real this actually becomes, right? So you've got to look at it, from the prosecution side. This is why it was brought about. From the company's side, it is to get this immunity or the waiver of penalty. Save yourself lots of money in litigation, because antitrust litigations are quite expensive globally as well. Even if you are found at fault eventually and you don't get full waiver, at least in India, I know of 3 matters where the CCI, after finding a party guilty, did not impose a penalty. And that wasn't the first mark. It wasn't the first one who had applied, right? So they said, okay, because everyone has come clean on this, we're not going to impose a penalty. We're going to reprimand you hard. You're going to remain in the scanner, but they kind of waived it all for everyone, right? And it can also be used for business benefits, because effectively what you're doing is, these are all normally big boys clubs, right? We have seen where a company has blown the whistle, the stock price of the other competitor company crashes, and the bad reputation, etc., then kicks in. In the meanwhile, there are business opportunities that open up. So it's an amazing little thing that flows out over here, right? Interestingly, in India, there's also a matter where so there was an alleged cartel between 3 companies. 2 of them became whistleblowers. Okay. I was for the 3rd company. Through cross-examination, we were actually able to prove that despite 2 of the 3 so-called conspirators alleging that I was a part of it, I was not actually a part of it. So within the leniency regime, where things have transformed now, Sumit, is that earlier there used to be, till 2016-17, you were not given access to a lot of information. Even now there's strict confidentiality, but now you're at least told, okay, what is the case against you? You're given a chance to kind of defend yourself. you're provided redacted versions of the case against you. Earlier, they wouldn't tell you anything. You were really shooting in the dark over there, right? So in the evolution of this, one, you're being given access to enough information to be able to kind of defend yourself. Two, you have the right of cross-examination, which otherwise earlier was not being readily given, right? So you're being able to confront people. Three, you have instances where you've got 4 to 5 applicants. And the critical part for everyone to understand amongst the student community is that it's not necessarily that the first one always gets the total waiver, right? You may become the first marked person, but if your disclosures are not vital enough, or if you have still held back information or documents, or you have actually not cooperated thereafter, or you have sought to withdraw later, that immunity is out. And then you're in serious trouble, right? So you've got to really, it's a very delicate balance. And, leniency plus is another chapter by itself. We'll get into it later as we go along.
So this takes me to Nikita, of course. And Christian has a couple of comments, but Christian, I would come back to you once we had this round. Nikita, I mean, you have already written a chapter on leniency, right? So what Vaibhav has already taken us through the practice. I mean, how do you see it? I mean, where do we stand when it comes to, let us say, the purpose is to strengthen leniency regime, hypothetically speaking, that we agree that this is required, right? So, I mean, where do we are? I mean, please feel free to disagree in case you feel that we do not require leniency at all, because this is, I mean, please feel free to. Yeah.
Thank you so much. And thank you, Weber, for setting the tone for in the Indian context. Now, I will be breaking down the law. So I will try and read between the words and say how far this draft legislation or these lesser penalty regulations are going to add anything substantive to the existing regulations that we already have. 3 things we have to be very, very clear of. The panelists already would know it. First is deterrence is directly proportional to penalty, which is directly proportional to leniency. And leniency plus is directly proportional to penalty plus, which is directly proportional to omnibus. And the last is uncertainty is directly proportional to lack of incentives for the leniency applicants to come forward. Now, like Weber mentioned, we have had leniency since beginning, which is 14 odd years now in this industry. We have 20 odd applications, 20 odd cases through leniency, I think. I might be wrong, please correct me with the number. And most of the cases have come in post 2021. So now what is the reason behind that? I'm going to go back and say deterrence is directly proportional to penalty, which is directly proportional to leniency. India does not have a lot of cases coming in through leniency initially because our penalty wasn't strong enough. Now, when I talk about turnover under Section 27, 10%, so all of these things are already taken into consideration while they are forming a cartel. So it's very important to understand that anybody who enters into a cartel takes into consideration 3 costs: the monitoring cost, the coordination cost, and the legal penalty cost. So since it's a civil wrong that happens in India and it's not a criminal deterrence, the cartelists have already taken all of this into account. So for them, going into leniency is not too incentivizing. Rather, in India, it has become sort of a disincentive. And I will tell you why, one after the other. And here I'm trying to break down the law. So the first problem exists with the definition of applicant in the lesser penalty regulation, which says that you are or were a member of the cartel. Now, the problem with this definition is they assume that you're a cartel member. So that means it's a pure admission of guilt. However, that's not what there's no clarity on that. Let me just take 2 examples. One is the flashlight case that happened in the 2017. And the flashlight case was a case through leniency applicants. All 3 of them had filed it post the zinc battery case. The commission eventually said they exonerated 3 of them, saying that there is no cartel that happened because there was no determination of sale price as per Section 33A. Now, the problem was, I'm saying I'm a leniency applicant, and according to the definition of applicant, I should be a member of the cartel. But CCI is saying, oh, hello. No, you didn't do anything wrong. You were not a member of the cartel. Now that's okay. So that's one of the big problems. And NCLAT then later on, in one of the cases, said that it automatically means admission of guilt. Fair enough, NCLAT said that. 2020 came, the beer cartel came. So out of the four of them applied for leniency eventually. Crown Beers also said that I also want to apply for leniency. The decision came out, they said, Crown Beer, you did not do anything wrong, so I'm exonerating you of the liability. And you're not an applicant as per the definition under the draft penalty lesser regulations. So NCLAT said it's an admission of guilt, but beer cartel came post that and said, no, it is not an admission of guilt. Now, the new draft lesser penalty regulation does not throw any light on it. They have not, I will not say they have not bothered, but probably they could have done a little bit more when they are doing this exercise. They should have thought about all of these because the cases have already come. Even if we have 20 odd cases, there are lots of issues that have been already there. Now, the second problem with the definition of applicant, it says you're an enterprise under Section 2H. But then they say that, I'm sorry, if you're a single economic entity, you have to file two separate applications because you will not be considered as a single economic entity under Section 2H for the purposes of leniency. I mean, for applicant, you are an enterprise as per Section 2H, but for the purposes of joint application, I'm so sorry, but you're not a single economic entity. So, I mean, shipping cartel said that to us. They were, I think OP3 and OP4 said that we are SCE. Please let one person file it. They said, no, we don't have a concept of joint application in here, and we will not allow you. You have to come as two different applicants. Of course, this is in vast contrast to what happens outside. The EU has the provision of joint application, and as far as I know, even UK has, even Japan has. And if my knowledge goes correct, 2006, the Lawfin Istria versus Commission case, they said there was a joint application that happened in the leniency part, and they went ahead and said that there is no bar on joint application, so we are going to allow it. And then in 2007, eventually, in the leniency program, they added that you can file a joint application. Now, in the new draft penalty regulation, again, there is no clarification on that. Now, let me come quickly to the second point that I want to talk about, which is, I said, uncertainty is directly proportional, lack of incentives for the parties to come forward. Now, we do not, in spite of these draft lesser penalty regulations coming in the year 2023, we do not ever thought of going through a pre-consultation stage, which happens in the EU, in US, in Canada, everywhere. Now, again, why is this pre-consultation stage so important? So that we don't repeat, or Commission does not repeat the mistakes it did in Flashlight and beer cartel. Flashlight, they went ahead and said that mere exchange of information will not amount to AEC in the market if it is not implemented. All right, good enough. 2020, the beer cartel said, there's a mere exchange of commercially sensitive information. Even if this did not result into determination of sale price in the market, it is okay, but it is anti-competitive in nature, which was upheld in the paper cartel and eventually, I think, in the shipping cartel as well. Now, if pre-consultation would have happened, the leniency applicants would have been very clear whether their conduct amounts to an AEC in the market or not. Now, what is happening is all of these people are using this as a mechanism of precaution. They are coming to the Commission, wasting the Commission's resources, saying, you figure out what we are doing is wrong or right. We have no obligation to do that. Why? Because you don't provide us a pre-consultation stage. So we are going to just come and tell you that we are doing this wrong. Now it's up to you. And the burden of proof is essentially on the DG. If you look the way it has been working, Regulation 3, Regulation 4 of the draft penalty lesser regulation, they're saying the burden of proof is on the DG to prove that there is a cartel or not. Why? Because we do not have a pre-consultation stage at all. So as an applicant, I do not have certainty as to what I'm doing is anti-competitive or not. So just to save myself, I will rush to the Commission and I'll say, at least I'm filing for leniency, then you decide my fate. Now, the third very big problem is the conditional leniency. Lack of conditional leniency. Now, what does that essentially entail? I'm sure my aim is just to go ahead and tell all the people who have joined this particular conference that conditional leniency means that when a particular person is applying for leniency, he gets it before the decision comes out. The Commission tells you that you are eligible for this much percentage of reduction in your penalty. And you're very certain what is it that you're going to what is the penalty that you will have to bear. Now, India does not have that. And what is the problem? The problem is it's a game of waiting. So by the time the commission's decision comes, we do not know whether we are the first applicant, second applicant, third applicant, what is it? Second, we don't know what is the percentage of leniency reduction we have gotten. And third is we don't know even if we have gotten leniency reduction. Now, if you look at, interestingly, the case that happened before Nagrik zinc dry battery case, opposite the party 2 and 3, they were given 30% and 20% reduction, even though did not add any significant added value, only on the basis that they merely cooperated. And then came Nagrik Chetna Manch, opposite party number 5 and 6, they said, oh, you cooperated very well, thank you, but you did not add any significant added value, so we will not give you any reduction. Now, why is this happening? There's so much of uncertainty here in the regime that as an applicant, I would not want to come forward. Rather, this will act as a disincentive for me in the first place to come for leniency. Because commission is also not clear on what grounds to grant them. And for that matter, there is no certainty that is being given to the applicants also. Now, there are a couple of more things that I want to add on, which I feel that draft penalty lesser regulations also did not answer. But I think I'm going to give a certain room to the fourth panelist to speak and probably come back to these points again. Right.
Most certainly, Nikita. This takes me to Spurti. Spurti, question is, more or less the same, that, first of all, if let us say there is an agreement that leniency is certainly required to burst cartels, right? How far these regulations have fetched us to reach that ideal stage? I think Vaibhav and Nikita have given quite an Indian context, and Christian has given a European context. We would love to know your thoughts.
So I just wanted to start with the what Vaibhav has mentioned. Like, this is more like a whistleblower policy, like it's a protection to the whistleblower. So I just wanted to start on that context. And in my feel that we need to have this incentivization towards preventing of cartels. But agreeing to what Nikita mentioned, like the irregularities in the law, the ambiguity, for example, like, not having fixed pattern in the imposition of penalties and no proper parameters or quantum merita to determine the amount of penalties. Like, we are mentioning like 30% of deduction is there, 20% of deduction is there, but on what merits, like, that depends from case to case. Again, going back to my first one, what I mentioned, there is no fixed pattern. Even in the present draft rules, the CCI has my bandwidth is low. Okay. Even in the present draft rules, the CCI has not even a elaborative manner, has not given the exact or the specific, not necessarily specific, maybe a broader outline of what are the parameters that could be with regarding to this determining the penalty percentage. That is one thing. And also, now we have the applicant. In the applicant, now we have the enterprise, as well as it is applicable for the individual also. So applying the whistleblower concept to the individual, an individual comes and files an leniency application, he's at much more risk when compared to an enterprise. Like, for that example, if the individual is an employee of that particular company and the individual is coming forward and informing the commission about this particular cartel happening, and there is no proper confidentiality clause is mentioned, but it does not exactly match to or it does not exactly protect the individual whistleblower, or it lacks like the protection. Because we have seen in the earlier cases where the CCI, after granting the order, they were mention of this, the document has been received, this particular information has been received from this particular opposite party, this particular applicant has given us the information, it was wide open. But however, there should have, it should necessarily have certain kind of information which should be restricted only for the commission and which should not be out on the public. That is one aspect I would like to add, the confidentiality clause, especially when we are including individual leniency applicant. That's all for now. I would like to come back again.
Sure. So thank you so much, Spurti. Again, this really sheds light on this important provision. Christian, I come back again to you. I mean, I'm more interested into two concepts which sort of Nikita and Weber brought forth. One is what is the position in Denmark and larger Europe when it comes to joint provision for filing for leniency. This is one. Secondly, what also Nikita brought forward, that is, if let us say there's a single economic entity, right? So is this the case same in Europe as well, where they are required to file two applications, or a single economic entity can in a single application talk about two different cartels and two different industries, combined with your various other thoughts?
I would like to start another place, because what is essential to understand about cartel is that, of course, you have very evil companies who intentionally engage in infringement, but quite often you unintentionally end up in a cartel. And I think that the Indian beer cartel that Nikita mentioned is a really good example of this, because if I understand the fact correctly, it was Anheuser-Busch who bought a local operation, and as part of the due diligence process, they actually identified a cartel which they came forward with to the competition authority, allowing them to proceed with a case. Some of the other members are Danish Carlsberg and Dutch Heineken. And I think it is relatively safe to assume that the top management here in Copenhagen and in Amsterdam did not know about that local beer cartel that was operated by a subsidiary in India. And that speaks to what often happens is that group legal doing internal compliance, they identify something that looks wrong locally, and they look for a way to get out. And that is, of course, to ask for leniency. So leniency not only destabilize cartels, but it's also provide a way to get out for group legal when they identify local infringement. And just to give you some idea about how a cartel actually looks and how leniency works in practice, I would like to show you something. And that is this. Can you see the movie, The Informant?
Yeah. We can say
it's. I really recommend it. It's really, really entertaining. But it's about a real cartel that's been turned into a Hollywood movie. It's the Leniency cartel. You can actually find the hidden camera on YouTube, and you can watch the movie. And in that movie, you can actually see how a cartel operates in practice and how you infiltrate it. Now, regarding your question, is managing a leniency application is something that is really, really, really complicated. It is become more easy within the European community because the laws are harmonized. Because if something is an infringement in one country in Europe, it's also an infringement in other countries. And there has been some national harmonization dictated by European Union regarding leniency. So all European countries has a leniency system that are in principle identical. And you can actually recycle leniency application across them. So it is much more simple within the European Union, but of course outside it is a bit of a nightmare. But locally, lawyers are always available for a very small and almost insignificant fee. And I don't know about India, but I would imagine that most countries also apply this single entity doctrine, which means that anything that happens in subsidiary is actually something that can be attributed to the group legal and the group as entirety. Did I address your question?
You did. Thank you so much, Christian, for answering the question. Weber, I am really interested. I mean, at one point of time, you said that there was a second and third applicant. They never filed, or I mean, they filed for as a second and third priority status, and they were given a waiver of more than 50%. Right, if I'm correct. Right. So I really wonder. I mean, isn't this in clear sort of outside the ambit of the regulations, where they have categorically mentioned that the first status would maximum be given 100% waiver? On the contrary, a second applicant at maximum can be given a 50% waiver. Or I mean, there is some sort of rule. There's some sort of scope of interpretation. And I mean, I would come back to this.
No, sorry. Please go ahead. Please complete.
Yeah. So I'm talking about hard, strict text of the law. Yeah.
Right. So in that matter, interestingly, what happened is it's not as if they said that we're putting, say, $1 million penalty, and now Weber, you were the first applicant, so 100% Weber, Christian 50, Nikita, in that table. No, they said we find there to be a cartel, but we don't think that it has caused enough of an appreciable adverse effect. My point would have been that if there is no AEC, then how's there a cartel in any case? Because the presumption does kick in. But be that as, and that's not the only matter, by the way. There have been quite a few matters in the regime here where, despite coming to a conclusion that there is an offense, they have not penalized at all, irrespective of leniency. Right? Now, a couple of them were in the COVID period. So I don't know whether that had any impact. It should not have had, because it's got to be by the book, so is to say. Having said that, Sumit, we must also appreciate we are a 14-year-old regime, right? We're running very hard. I mean, you've got today, whether you look in the tech sector or you look at the cement cartel matter, or in AOD, you look at the DLF matter, you've got some serious judgments coming out, which are going neck to neck with some of the well-established, regulatory regimes globally, right? They are learning on the job. They are trying to kind of push it through and say that, we are not. At one point, the CCI was being looked at as if it's got fangs of poison. Really difficult regime out there, right? Because in 2 years, you had these host of judgments coming out, starting with $1 billion plus penalty on the cement cartel and etc. And then suddenly it slowed down, right? And why I'm trying to tell you that is that it's the evolutionary process for any body, right, which is still new and nascent. It's going to have its ups and downs. And that's something, again, to what Nikita was also mentioning, right? That there needs to be greater clarity. And the reason I can say that is I was also the Competition Commission of India's lawyer for 8 years, right, as a special arguing counsel for them. So I could do it was an interesting one. I could do my private practice. But if the commission wanted me to defend any case for them, say the constitutional challenge, etc., right? So they brought me on board for that. So, one was privy to how the regime was kind of coming out of the hangover, really, if I may say that. So don't confuse penalties with and the exemptions or the waivers with saying that it's only the leniency regime which is going to kick in over here. The problem is you don't have a benchmark at all, right? For instance, till Excel Crop judgment, Christian, for your understanding, there's a judgment by the Supreme Court in India called Excel Crop, right, which effectively interpreted the penalty provision in India. And the penalty provision said 10% penalty on the turnover, right? Until that judgment came, it was on the global turnover. Then the Supreme Court interpreted to say, no, the turnover is going to be only qua that product and for that offense only. So it's not going to be, if you're a multi-brand company or a multi-product company, it's not going to be on all your companies or on all your products. So effectively what it did was, what would have been a much larger penalty for a lot of people, it started becoming minuscule, right? And that's where Nikita's point really holds good, that suddenly it became almost an incentive for companies to cartelize, because now the penalty that you're talking about is up to 10% of that cartel and that product. They'll always recover that if the cartel is successful, right? So, with due respect to the Supreme Court, I'm not the biggest fan of that judgment, but be that as it may, that's the way the law stands today in the country, right? Now, if you look at the penalty provision, there's not clarity, not enough clarity there. There is absolutely no math or system or matrix as to who would be penalized 7% or 10% or 0.05% of the profits. There's no system. That to me is a bigger problem.
Yeah.
And
so yes, absolutely.
So all of that, I think that'll go a long way.
Yeah. So yeah, thank you so much, Vaibhav. And I mean, Nikita and Spurti, I have a lot of questions for you in the sense Vaibhav has raised very valid points. So I'll sort of take a bottom up approach. I'll start from where Vaibhav ended. Right? We have lesser penalty guidelines at one place, right? But should the competition commission should also think about that, let us say, sort of this entire concept of aggravating and mitigating circumstance, where let us say I have not at all filed for leniency application, but even as a hardcore penalty order, there would be ultimately some circumstances in which a penalty would be imposed. So should the CCI also look into sort of issuing some guidelines, as Weber correctly pointed it out? Because as a respondent entity, how would I really come to know that a 1% penalty would be levied on me, or let us say as contrary to the 10%? Because I sort of did my research into it, and in a lot of judgments, at least in the starting 5 or 6 years, there is no realistic reasoning given. Right? There is no realistic reasoning given on how do they arrive at 5% or 7%. Right? So this is one. Apart from that, I mean, is it also to correct? I mean, what I understand from what Weber has said, is it correct to state that the whole idea of leniency regime is to find some sort of compromise, because it is clear that we are going some sort of, in some cases, we go out of the text of the law. And I specifically point out one judgment where some of the Haryana government state officials were involved in the matter. DG sort of served them notice to file their ITRs, and these officers sort of approached the Delhi High Court, and the court sort of quashed the judgment, and the CCI has not passed any order in that matter. Which, to my mind, I really don't know what is the fate of that judgment and what provision did they go. So Weber has something interesting to add. Weber something to add to that. So
no,
yeah,
Nikita, I'm sorry, I don't want to jump into Nikita's turn, but I think there is a judgment. You're talking about the DTCP matter, the Haryana officials with land matter. Yeah, there is a judgment.
Okay, yeah. So Nikita, yeah, please.
I'm not sure what do you want me to comment here, but let me just begin let me just take the context from Weber's speech. So I agree with Weber when he says that there's a lot of uncertainty that is there, and probably because we are a new regime. And I totally agree with that. But the problem is that we are still not able to learn from the own mistakes that we are doing in the cases, right? Very, very basic points. The question is, what are these draft lesser penalty regulations adding to, which is not there? Now, that is interesting because it is not adding to anything. Right. One thing I will not take away, they are also included in the applicant a hub and spoke person. So it's not necessary that that person has to be actively a member of the cartel. He is an upstream or a downstream or an unrelated market and has facilitated the cartel. He can also be a whistleblower in this regime. The second, I am very happy that these people have clarified slightly on the confidentiality part also by making an exception to General 35 of the regulations, which we were not aware of unless Nagrik Chetna Manch had come. And they said the confidentiality under this Regulation 6 of the LPR does not extend to under General 35 of the regulations, to the extent of it has been discovered by the DG. Right. Of course, the identity remains confidential, but if post that DG has discovered using your documents anything extra, then General 35 will not cover it automatically. You will have to apply it separately. So that's a good thing that they have clarified it. Again, the confidentiality standard in India is extremely low, even post these draft lesser penalty regulations. That's the first thing. Now, another very remarkable thing that everybody is talking about is leniency plus. Now, I really like that concept, but the problem is leniency plus will do no good. Rather, leniency plus is going to incentivize the cartelists to enter into more cartels and then go to the commission, get caught in one, and tell the CCI that, oh, we are also a part of this. Why don't you take care of it? I will anyways get 100% there. Now, why do I say so? Because okay, both the ways. Now, because first of all, there's no penalty plus. Now, when I say about penalty plus here, I essentially mean if I don't disclose another cartel that I'm a member of, what is my downside of it? What is the downside that I face if I do not disclose it? Because like you very well mentioned, Sumit, aggravating and mitigating circumstances. So even when we are giving leniency, they don't really take into consideration the role of the cartelist member who's applied for leniency in the entire cartel. For example, in the European Union, please correct me, Christian, if I'm wrong, they do take into consideration that if you are the perpetrator of a cartel, your leniency, the amount of leniency that you're going to get granted might change because you are the one who've coerced people into a cartel. So it's the coercion thing that I'm talking about. In India, we do not have any aggravating, mitigating, or coercion factors yet in our lesser penalty regulations that says that, all right, because you are the perpetrator of the cartel, let me not give you that penalty extra. So that's also a very big issue. So according to me, we should not celebrate. I think it's too early on to celebrate that, oh my God, we have a leniency plus, because it's going to be essentially useless without there being a penalty plus. So, it has to go together. It's a package. I'm not sure why we haven't thought of it or put it in. I mean, probably Weber would be able to answer this better as to why haven't we done this, and how do you think that leniency plus without this mechanism would anyway do any good to the existing system?
So can I take that? Just very quick.
Yeah, please.
It's a very interesting one, Nikita, and I think that's a very fair point as well. But I do believe that the leniency plus could work, and I'll tell you where I'm coming from, right? In a couple of cases, especially recently, what's been happening is that when they were investigating into one offense, right, they realized that during the course, and I was on the defense on that one, right, we realized that the evidence in front was insinuating another cartel. And the line of questioning started on that front. And the clients were like, where are we going? Because can they then, something that's been produced as evidence in one case, can it be made the foundation for another case? And it can be. In India, at least it can be, right? We don't have the fruits of a poison tree principle in any case over here in India, right? So in such matters, and this question interestingly came in the board meeting, when we were sitting over there, to say, can't we disclose about that, or should we not intimate the CC about it? We're not sure whether there is a cartel or not, but should we not? And we decided to do it. Now, if for instance, this leniency plus regime had been there, I think there would have been more stability in that decision. And B, it would have acted as an incentive. So if it were a 50-50 case, you would have definitely gone for it.
Right.
As well, right? So I think there could be, some upside to it, but yeah, a lot needs to be done.
So thanks, Weber, for taking this question. I come to Spurti, and Spurti, I sort of repeat my questions because there's a lot to discuss actually, and there is a constraint of time. So my two questions, as I asked to Nikita also, is that I come back to again what Weber said. This really makes, at least to me, a lot of sense. The leniency regime is fine at its own place. But when it comes to imposing hardcore penalty, right, is there merit in suggesting that the Competition Commission should come up with how to impose penalty, right? Mitigating and aggravating circumstances apart, should there be penalty guidelines as well? What right now we are discussing is the lesser penalty guidelines, which are hardcore leniency, right? But I am talking about hardcore penal provisions because we have a lot of cases where thousands of crores of penalty has been imposed. Right? So is there merit to suggest that penalty guidelines should exist? Second question is there some merit to further say that the larger point of amnesty programs, which is to club commitment scheme, settlement scheme, and leniency, is to sort of come to a common ground and achieve quote unquote efficient allocation of resources? So yeah, if you can respond to these questions, it would be helpful.
Okay, answering your first question, Sumit, I personally feel that we need more rules and regulations on both hardcore leniency penalty and as well as penal provisions, because what are there, as Nikita mentioned, it's too early to celebrate. And we can, and also bringing in what just Vaibhav mentioned, like leniency plus could be an added incentive. So I personally think it's too early to, maybe it will be a pro to the existing situation, or again we never know how it is going to play out, because there are various multiple permutations and combinations involving in when it comes to applying leniency plus to the existing provisions. Because the present draft rules, they concentrate more on lessening the penalty rather than providing more on the leniency plus. So they have just incorporated the provision, but however, the rules and everything on that are not particularly as clear. And while speaking so, even on the this one, leniency rules are not exactly clear, but there are still certain ambiguity between two clauses. I found in two clauses there are certain ambiguity, especially with regard to the procedural aspects of the clauses. For example, we have there is a clause on forfeiture, which says that once the applicant has withdrawn he has withdrawn the leniency applicant, it is mentioned that he is no more eligible or whatsoever. But the withdrawal amounts to this one. But how about the information what he has provided in that process? From the time he has applied and from the time he has withdrew the applicant, in between, he must have provided some information, right? And if that information is vital and that information is sensitive information, which has led the DG to come to a prima facie evidence or whatsoever conclusion, or it helped in his investigation, are they being provided any sort of lesser penalty? That particular part has been not completely answered in the draft penalty provisions. That's one aspect where we are still lagging. And also, Christian should correct me, when we are coming up with these kind of draft rules, it is always advised by the jurisprudence maybe to maintain to the international standards. And I personally don't think these are equivalent to the regulations. We are okay, this is a way forward, definitely, but still we are much more lagging when compared to the international standards, maybe EU or Japan. Japan is more stringent in nature, US, Canada. So we are still backward when compared to other international regimes on antitrust laws. So this is my take on first question. And second one, I'm really not that well versed. So can you just again repeat the question, like, if you really don't mind?
So my question was that, see, the way I see it as, be it the leniency regime or the commitment or settlement, right? The aim of the commission is to sort of find a middle ground, right? Because there is no point in running full hardcore proceedings running for years and years. So would it be correct to state that ultimately the amnesty program sort of achieves, quote unquote, economically efficient allocation of resources? Because as Nikita pointed out, that these respondents keep wasting CCI's resources, investigation, and so on and so forth, and ultimately public resources are being wasted, right? Which can be directed to other cartels, right? If they sort of are able to set.
I'm sorry to interject, Sumit. I don't mean to say that they are wasting the resources. I'm just saying that they are using it as more of a... I'm so sorry. I'm just trying to clarify here that I'm not against what CCI is doing. I'm very happy with what they are doing. The only thing is that I feel because there's a lack of pre-consultation stage, like Vaibhav also categorically mentioned, that we were not sure whether we are actually breaching another law. Now, if we had a pre-consultation stage in the draft penalty lesser regulations, this would have been easily answered to, and then lesser penalty plus would have been a very, very good takeaway from this draft lesser regulation. So I'm just trying to say that maybe we had to do couple of things more beyond just the leniency or amnesty plus. That is what... So I'm not saying we are wasting the resources categorically, but definitely what the companies are doing is they're not very sure what they are doing is wrong. So they are going to the commission, surrendering them, and then saying, you decide. So now the commission still has to make a prima facie opinion. DG still has to investigate. Now that entails resources, which anyways we don't have enough. So, we are here acting as an advocate. As a regulator, we are acting more like an advocate of a company, trying to tell them that, oh, have you crossed the line or not? So that is what I had a slight problem with. Otherwise, I'm very happy with what CCI is doing.
So as I know, it's just a general common notion everywhere. Every law when passed has its pros and cons. So similarly, I think this draft regulations also has its own pros and cons. And as rightly pointed out, unless we have other regulations coupled with on settlement and on settlement or reconciliation or whatsoever, these provisions, a plain mere passing of these draft regulations is not going to make it in a better situation. It is going, again, it's very too early to judge, and like so far we have no quantitative evidence to say. So it's again too early to judge, but again, coupled with some other regulations, I think the result of it would be more effective. Yeah, that's what I would like to think.
So thank you, Spooty. I am mostly done with my questions. So I think panelists can give their concluding remarks. Christian, please go ahead. I'm mostly done with my questions.
I have two comments. The European leniency system was introduced in 1996, if I recall correctly. Then it was refined in 2001 and 2006, and recently it was extended to cover all the member states. And there might be additional improvements. So meaning that we are technically on our fourth leniency system. So you don't need to have a perfect system. But I think that there are so massively advantages of having a system that you should just simply get it. Obviously, it should be structured such a way so you don't have to, companies cannot come forward and have the enforcer act as lawyers. They need to admit or imply that they have broken the law, and then you can either, okay, well, we will not look at it, we'll just put it on file, and if we actually identify a cartel here, we might come back. The second thing is that I think it is essential to have transparency. India is a very interesting market for a lot of Western countries, but you are in an area where there's a lot of countries that has bad reputations. So obviously, the more you can put out in English that allows company from Europe or US to view what is actually the legal position in India. That actually quite helpful, because a lot of European countries have subsidiary in India, but the group legal is in the headquarter, and of course they take a lot of active step in kind of compliance, monitoring, etc., to prevent local infringement. And here it really helps that they can actually understand the law, and the closer the system are to something they understand, the more happy they are. One of the things that really frustrate me when I travel is that whenever the electricity system are different, I cannot just plug in my mobile phone or my computer. I need to bring a special charger. So, the more conversion and harmonization you have, the more helpful it is. So my recommendation would really be, go ahead, get a system out. It might not be a perfect system, but any system is better than nothing. And make it as transparent as possible with putting out guidelines where you explain all different kind of steps. So I, as a group legal in Copenhagen, actually can evaluate the position in India, because that makes me more comfortable in investing in India.
So, I think Christian has summed it up very, very beautifully. There needs to be transparency. And that is something entities, even in India, right, not just global players, they all seek the same. They want a definitive formula in place so that they know what they're going in for. We as lawyers, very often, it's terrible to tell a client that it could be from 0 to 100, it could be anything. Right, and there's really no way to assess it. We sometimes look like absolute idiots on that one. But I do believe that the one thing that's going to be extremely critical for this regime to do well, it's got a good groundwork, and we're in treaties with almost 150 countries as well now on this. But only if the Commission finds its teeth again, only if they are ready to do this in a time-bound manner, only if they're able to actually, have these judgments come, put the stiff penalties, so that there is a fear in the community, in the cartel communities, that they could be caught out. Because if you look at the first 5 years versus the next 6 years and 6 years, if you were to divide it, there was tremendous action in the first 6 years. Post that, things have really slowed down here, except for the tech space, right? Because, and that's hogging the limelight. But until and unless there's that fear that's evoked, you're not going to have the leniency regime or any other regime really do well, in that sense. And secondly, I've been a big advocate for criminal penalties for cartels as they exist in some countries like the US as well. The pushback has often been from the policy people that, we're not yet mature enough as a regime. And my point is, until you take a dive, you're never going to learn how to swim on this one. Because once that is done, according to me, again, you'll have a phase of uncertainty, but that's what will push the message out that there's a very serious regulator out there. It's got a macroeconomic impact, not just a microeconomic, not just for companies. It's at an economy level that this is going to have an impact. And that's where you'll see the benefits of leniency come in. Thank you.
Nikita, please go.
I mean, really, really apt. And I'm also one of those who advocates criminal penalties. However, let's start slow. So I have a couple of recommendations that I would like to place it here. One is clarify and have a little bit more clarity with respect to the confidentiality part as to how much of the information is going to remain confidential, how much of it will be shared, and what happens in case it is breached within the confidentiality ring as well. Now, the second is criminal penalties. Maybe it's I think, deeper dive. We can start off with simple things like more efficient administrative penalties on individuals at the moment, because individuals are more scared than any other entity. So they're going to run faster, is what I believe, to the regulator. And if we have administrative penalties in place, which includes disqualification or disassociation, I think it might really start working in our favor. And also specifically in public procurement cases, like how it happens in the EU. Even in India, for that matter, we have the GFR in place, wherein they say that if you're a part of Prevention of Corruption Act, you've been alleged under that, or if you've been alleged under the IPC, you will not be allowed to take part in the public procurement case for a couple of years. So if we have those sorts of penalties also in the regime, I think it will help us. And one more thing that I would like to very quickly touch upon is we have no cases as yet decided under Section 53N, which is private antitrust damages. And private antitrust damages are one of the major reasons in US and EU and UK for the lack of cases coming in leniency at this point of time. We have no clarity on that, no jurisprudence on that. I think 9 cases are pending under Section 53N is what I understand. So if we are able to take these, if we already have a guideline in place for those cases before they come out, I think it will also incentivize leniency applicants more, because at this point of time, it can happen tomorrow that some of them might be liable in a follow-on action claim under 53N, and they would be regretting the decision of going in the leniency in the first place. So, that clarification, I mean, we can be a little more far-sighted is what I think is my recommendation. So that's all. Thank you.
Spurti, please go ahead.
Yeah. So summing up, I think the CCI coming up with the idea of releasing this draft lesser penalty rules is a great step forward. But however, in order to stay relevant, the CCI also should time and now keep amending it or adding more relevant provisions. For example, like relevant factors to be considered when you are granting leniency plus. These there are certain minute aspects which have been missed. Confidentiality clause is one such, and there is a gap that needs to be addressed between withdrawal and foreclosure, as I pointed out in my previous question, when answering the previous question. And there is one more a procedural aspect with regarding to the application of principles of natural justice, where when an individual or when the CCI feels that this particular lenient application is not valid and they are withdrawing it, or they are he's going and say, or when there is a situation where the DG finds that during the investigation or the documents and information provided are not sufficient, the individual or the enterprise is not given an abundant opportunity to represent his case. This particular procedural aspect is still missing in the guidelines. Like these minute corrections, if the CCI could rectify before bringing in or before bringing the finalized version of the draft, I think this is going to be a a good start for the Indian society.
Yeah, thank you so much, Spurti. We have already overshot the time by 15 minutes. Whether we have a question specifically addressed to you, would you be able to take it if you have ample time, or we can close it?
No, very happy. I just, in fact, I think replied to it as we were talking.
Okay.
I think that's the one that you're talking about, the criminal.
Yes, absolutely, yes.
And I think Christian's got a very interesting point on that as well. You know, it cuts both ways.
So Christian, you can sort of come out. I mean, if the time permits, Christian, if you want to come out, and I think there's some comment you have posted on the criminalization, the limitation on criminalization of cartel offenses, it would be helpful for us.
I have mixed feelings because, you know, on one hand, some of these people deserve to go to prison. Now, the problem is, of course, that, you know, if you are a CEO of a company, you're probably much more willing to, you know, close the case and pay whatever fine if it is just a shareholder who pay. But, you know, the very moment I can get a personal fine, or I might even go to prison, you know, my interest in actually fighting everything inflates extremely. So, you know, I'm not particularly fond of criminal infringement, particularly not if it involves personal liability, because it creates other problems. So to me, I actually prefer the European system where you just get a really big fine, but it is the company and the shareholder who pays. It is not the individual who might actually be responsible, because you create so many other problems. Besides, you know, I'm unwilling to settle. It can also create problems because, you know, the authorities can no longer share information, because if I have, you know, I might actually go to prison in the other jurisdiction due to facts that I've told you. So there's so many problems involved in criminal sanctions. So you really have to be careful before you introduce them. Having said that, you know, it's not that they don't deserve, you know, severe punishment. It's more a question about there's so many practical problems about it.
So very quickly, I'm sorry if I just come in. I'm not even on whether they deserve it or not. I'm more from the perspective that I think, again, a heavy hammer, the fear of criminal sanctions or heavy penalties will have a lot more people worrying about it, being cognizant about it, and therefore coming forth. And at least in the Indian penal system, there can be the whistleblower concept, even in the penal system, can be given immunity, right? So I'm saying that becomes a serious incentive as the management as well to say, I could be, you know, I could get immunity from criminal prosecution as well. Let me go blow this up, right? So, but yeah, it's a heavy debate, you know, and it'll keep us back for a long time. So thank you so much to the entire panel members.
So I suppose I would like to, you know, I would like to give my sincere thanks. I'm sincerely thankful to Christian, to Weber, to Nikita, and to Spurti for accepting the invitation. Since the time is less, there are a couple of questions, but I think we will have to wrap it off. We'll be happy to email these questions to the specific panelists if the participants reach out to us. And obviously, I believe that this conversation is ongoing, as it is very evident as to the difference of thoughts we had on the panel. And we'll certainly, we will learn on the job, as Weber has said. And a lot will come, as Christian has said. There will be regulations, there will be revisions, and so on and so forth. So I would like to again thank all the participants, and most importantly, the panelists, to take the time out and discuss this specific topic. Thank you so much, everyone.
Thank you.
Thanks.
Thank you, Christian. Thank you, Weber. Thank you, Spurti.
Thank you, Nikita, Christian, Supriya. Spurti, sorry.
It's fine. Thank you, Weber. Thank you, Sumit.
Bye-bye.
Thank you, Christian, and thank you, Nikita. Bye.